So XRP has won the SEC case, and it's breaking news. It happened yesterday, but I decided to do it today to collect more information and show it to you guys from all the tweets. There's a lot out there, but here is Eleanor Torres. She said George Soros says Ripple's programmatic sales, the other distributions, and Larson's and Garlinghouse's sales of XRP do not constitute investment contracts. And here you can see Securities and Exchange Commission versus Ripple Labs. And here is the summary judgment or the judgment from the judge. So basically, XRP is not a security and their sales are not constituted as investment contracts other than the institutional sales, which was a long time ago. Here is Larry Fink saying the two biggest things to happen to crypto, the Ripple decision and Larry Fink and BlackRock joining the crypto bandwagon. Very difficult for people to call this space scams, fraudsters, etc., etc. Listen to what he has to say here.
More and more global investors are...
And I'm going to skip here to the more important part.
An international crypto product can really transcend that. And that's why we believe there's great opportunities, and that's why we're seeing more and more interest. And that interest is broad-based worldwide.
Broad-based worldwide interest. This is not a scam. This space is getting legitimized right before your eyes, whether you believe it or not. People who come in late, well, they'll come in late. Sir Alderati says PSA for other crypto defendants. Check out footnote 20 where the court makes it clear that the SEC's theories, other than to institutional sales, are potentially very much subject to a fair notice defense. Boom. Brad Garlinghouse, he said that, and we said in December 2020 that we were on the right side of the law and we'll be on the right side of history. Thankful to everyone who helped us get to today's decision, one that is for all crypto innovation in the U.S. And here is, don't forget that XRP was registered as a virtual currency by FinCEN after a settlement back in 2015. So FinCEN declared them a virtual currency. The SEC declared them not a security after this judgment by the judge, and it meets the ESG standards. So what does that mean? Well, you have the most regulated crypto in the U.S. So there you have it, folks. Here's Brad Garlinghouse seeing some confusion on what the court's decision means. Here's a recap from our legal eagle, Stuart Alderati, who says a huge win today. As a matter of law, XRP is not a security. Also a matter of law, sales on exchanges are not securities. Sales by executives are not securities. Other XRP distributions to developers, to charities, to employees are not securities. So the only thing, like we said, that they considered investment contracts is direct XRP sales to institutional clients. So, and there will be further court proceedings on these institutional sales by the court's order. So that's basically a summary of it all. And here, in part of the ruling, Brad Garlinghouse tweeted this. He said the most important part of this ruling is that XRP as a digital token is not in and of itself a contract, transaction, or scheme that embodies the Howey requirements of an investment contract. This is now a matter of law, which is not up for trial. And after all that, Coinbase is relisting XRP, so has Kraken, so has Binance. All these exchanges are now relisting. And so, folks, we're back on track. And so, XRP is officially a virtual currency, not a security, and it's now one of the most, regulated assets above all these other cryptos. So, that puts them way ahead of the game, if you think about it. All right, XRP. Let's go.